Good day, everyone. My name is Jade G. Downey, and I'm from BSHM 3A, and I'm going to tackle about the laws regulating transportation establishment on Chapter 7. First, the learning objectives. Identify the laws affecting the transportation sector. Next is identify the rights of passengers of commercial transportation and explain the relevance of these laws to the promotion of tourism in the country. Then the topic outline. First is law on common carriers, nature of contract of carriage, then responsibility of common carriers, liabilities of common carriers for the acts of employees and strangers, registration of aircraft, seatbelt law, law on transportation of animals, law on importation of vehicles, public service laws, and traffic laws. So, the Philippines has become one of the promising tourist destinations due to extraordinary hospitality of the Filipinos and the diversity of tourist attractions in the country. However, one challenging aspect of promoting inbound tourism in the Philippines is the security and safety issue. On one hand, some of the best transportation and travel professionals are Filipinos. Example given, seafarers, pilots, drivers, flight attendants, cruise cabin crew, then aircraft mechanics, etc. On the other hand, some of the worst recorded transportation disasters and accidents is in the Philippines. The transportation sector is therefore greatly affected by this concern. This chapter will deal with the different laws affecting the transportation sector as they are integral and in the study of tourism. Law on common carriers. The primary law that governs common carriers is the Civil Code of the Philippines as clearly implied from Article 1766 thereof, which states that in all matters not regulated by this code, the rights and obligations of common carriers shall be governed by the Code of Commerce and special laws. Article 1732, common carriers are persons, corporations, firms, or associations engaged in the business of carrying or transporting the passengers or goods or both by land, water, or air for compensation, offering their services to the public. Discussion of the law. A common carrier is defined as one of holding itself out to the public as engaged in the transportation of freight or passenger for hire. It is one who is in the business of transporting goods or persons for hire as a public utility. A private carrier, in contrast, is not in business of transporting public employment, but hires out to deliver goods, not passengers in particular cases. Both the Civil Code and Code of Commerce give clear-cut divisions between contracts of carriage of cargo and contracts of carriage of passengers, because the rights and defenses in each kind of contracts are different from the other. Nature of contract of carriage. A contract to transport passengers is quite different in kind and degree from any other contractual relation, and this is because of the relation which an air carrier sustains with the public. It invites people to avail the comforts and advantages it offers. The contract of carriage therefore generates a relation attended with the public duty. Neglect or malfeasance of the carrier's employees naturally could give ground for an action for damages. Responsibility of common carriers. The law. Article 1733, common carriers from the nature of their business and for reasons of public policy are bound to observe extraordinary diligence in the vigilance over the goods and for the safety of the passengers transported by them, according to all the circumstances of each case. Article 1755, a common carrier is bound to carry the passengers safely as far as human care and foresight can provide, using the utmost diligence of very cautious persons with due regard for all the circumstances. Article 1756 in case of death or injuries to passengers, common carriers are presumed to have been at fault or to have acted negligently unless they prove that they observe extraordinary diligence as prescribed in Articles 1733 and 1755. Article 1757. The responsibility of a common carrier for the safety of passengers as required in Articles 1733 and 1755, cannot be dispensed with or lessened by stipulation by the posting of notices, by statements on tickets, or otherwise. Liabilities of common carriers for the acts of employees and strangers. The law, Article 1759, common carriers are liable for the death of or injuries to passengers through the negligence of or willful acts of the former's employees, although such employees may have acted beyond the scope of their authority or in violation of the orders of the common carriers. The liability of the common carriers does not cease upon proof that they exercised the diligence of a good father of a family in the selection and supervision of their employees. Enforcement of liability of common carriers. For passengers, victims can file a breach of contract of carriage or culpa contractual against the common carrier owner in case of death or injury. For strangers or pedestrians, victims can file a criminal complaint for reckless imprudence against the suit against the common carrier and driver on the grounds of culpa aquiliana or quasi delicto. Damages recoverable from common carriers. So first is actual damages, expense for medicine, hospitalization, etc. Number 2, compensatory damages, unrealized profits calculated based on the net yearly income and expected lifespan. Moral damages, award for death or mental anguish, fraud or bad faith. Exemplary damages, awarded to set an example or for gross negligence. Death indemnity, as per current court rulings. Number 6 is attorney's fees, awarded when exemplary damages are granted. Number 7, nominal damages, awarded when moral damages can't be proven to indemnify the victim for any loss. Nature of airline, bus and shipping tickets. The best evidence of a contract of carriage is the passage ticket. Under our jurisprudence, an airline, bus, or shipping ticket is a contract of adhesion considering that all the provisions thereof are prepared and drafted only by the carrier. The only participation left of the other party is to affix his signature thereto. In such situation, the Supreme Court ruled that the terms thereof must be interpreted against the party who drafted the same, in this case, the carrier. The discussion of the law, such contracts of adhesion are not entirely prohibited and are in fact binding regardless of whether or not the passenger or shipper had read the provisions thereof. It was held that even if the passenger had not signed the plane ticket, he is nevertheless bound by the provisions thereof. Such provisions have been held to be part of the contract of carriage, valid and binding upon the passenger regardless of the latter's lack of knowledge or assent to the regulation. The one who adheres to the contract is really free to reject it entirely. If he adheres, he gives his consent. Even if the conditions are printed in small letters, does not make the ticket or bill invalid. However, the courts will exercise greater vigilance when dealing with contracts of adhesion in that the said contracts must be carefully scrutinized in order to protect the weaker party from deceptive schemes contained in ready-made stipulations. This is in recognition of Article 24 of the Civil Code, which mandates that in all contractual property or other relations when one of the parties is at disadvantage or on account of his moral dependence, ignorance, indigence, mental weakness, tender age, or other handicap, the courts must be vigilant for his protection. Regulation of transportation business. The Department of Transportation and Communications is the primary policy, planning, programming, regulating and administrative entity of the executive branch of government in the promotion, development and regulation of dependable and coordinated networks of transportation and communication systems, as well as in the fast, safe, efficient, and reliable postal, transportation, and communication services. Then, it has the power, authority, and technical expertise to determine whether a specific transportation or communications project is necessary, viable, and beneficial to the people. Regulation of Air Transportation Business. Legislative Act No. 3909, passed by the Philippine Legislature on November 20, 1931, created his office under the Department of Commerce and Communications to handle aviation matters, particularly the enforcement of rules and regulations governing commercial aviation as their particular line. So it was amended files scheduling of airman and aircraft as petition of aircraft concerning air traffic rules, schedules and rates, and enforcement of aviation laws. So the creation of amendments. Legislative Act number 3909 created office under the Department of Commerce and Communications. Republic Act number 776 in 1952 defined CAB's powers and duties. Executive Order number 125 in 1987 created the Air Transportation Office. Authorized persons reserved for Philippine citizens defined as individuals, partnerships, or corporations with majority Filipino ownership and management. Civil Aeronautics Board, also called as CAB or CAB, regulates economic aspects of air transportation, supervises air carriers and their assets, sets and determines rates and charges, issues, amends, revokes permits and CPCN, requires presidential approval for foreign air carrier permits. CAB and ATO functions. Civil Aeronautics Board, or CAB, issues Certificate of Public Convenience and Necessity, CPCN. If, number 1, the applicant is fit, willing, and able to serve the public, number 2, the service is required by public convenience and necessity, then Air Transportation Office, or ATO, or AT, functions. Enforce rules for aircraft and air facility inspection and registration. Set and enforce air transportation laws, impose charges for public air utility services, administer the Civil Aviation Training Center, operate and maintain national airports and air navigation facilities, establish safety regulations for air commerce, investigate aircraft accidents, issue, deny, or revoke certificates, permits, and licenses for aircraft, airmen, and air agencies, registration of aircraft. So the law, only aircraft owned by or leased to a citizen or citizens of the Philippines and which are not registered under the laws of any foreign country may be eligible for registration. Marinas functions. Republic Act number 9295. Number 1, register vessels. Number 2, issue and manage the certificates of public convenience. Number 3, modify, suspend, or revoke certificates or licenses. Number 4, establish routes or zones for domestic shipping. Number 5, required service in essential areas. Number 6, set and enforce safety standards. Number 7, ensure compliance with operational standards. Number 8, inspect vessels for safety. Number 9, ensure financial capacity for safe services. Number 10, assess new service impacts. Number 11, ensure compliance with safety regulations. Number 12, maintain stable passenger or freight rates. Then number 13, hear and adjudicate complaints. Number 14, impose fines or penalties for safety violations. And number 15, investigate complaints against operators or shippers. Number 16, enforce penalties for law violations. And lastly, number 17, issue necessary implementation regulations. Regulation of land transportation. Number 1, historical context. Early means animals for transport with basic laws. Number 2, regulatory agencies. LTO controls vehicles registration, operation, and licensing. And LTFRB regulates the land transportation industry. Number 3, Clean Air Act of 1999 requires vehicles to pass emission tests by the Department of Transportation and Communications for registration. Accreditation of transportation vehicles by the Department of Tourism. This involves the minimum requirements for the operation, establishments, and maintenance of transportation vehicles in order to be accredited by the Department of Tourism. Accreditation by the Department of Tourism, although not mandatory in nature, increases the marketability of transportation vehicle. Standard requirements for tourist land transportation vehicles. Number 1, roadworthiness. Must pass inspection by the Department of Tourism, like age limits, buses or coasters, up to 10 years, or tourist cars, 5 years, luxury cars, 10 years. Number 2, equipment. Left-hand drive air conditioning, portable fire extinguisher, public address system for buses or coasters, first aid kit and emergency medicines, clean, comfortable seats, ample legroom, and storage space. Number 3, maintenance. Adequate garage and repair shop and sufficient parking space. Number 4, registration. Clearance from the Philippine National Police for regional registration or transfer of ownership. Standard requirements for tourist air transport. Adequate life-saving devices and adequate communication equipment should be provided in accordance with the requirements prescribed by the Air Transportation Office. Documents required for tourist transport accreditation. General requirements. Number 1, mayor's permit or municipal license. Number 2, business name, certificate or articles of incorporation or partnership. Number 3, proof of ownership or lease of maintenance depot or garage. Number 4, any other requirement documents. For land transportation, LTFRB certificate of franchise or authorization, approved transportation rates, vehicles pictures or like side, back, front with company name or logo. Additional documents as required. For the water transport, certificate of public convenience and necessity, Maritime Industry Authority. So first is approved transportation rates, vessels, pictures like side, back, and front with company name or logo, routes and schedules, additional documents as required. For air transport, Certificate of Public Convenience and Necessity, Civil Aeronautics Board. Approved transportation rates, plain pictures from the side, back, front with company name or logo, list of operations and maintenance personnel with ATO licenses, routes and flight schedules, additional documents as required. Accreditation of boat or bangka in tourism activity services. So the vessels of 20 gross tonnage or GRT and below providing water transport and tourism services. Requirements for accreditation: quality materials and marina standards compliance, equipment life-saving and firefighting equipment, life vest, first aid kit, lighting, flashlights, radio equipment, and waste bins. Boat or operator standards: at least 2 trained and licensed boatmen with ID cards and uniforms, proper garage and maintenance facilities. Then next is to eligible applicants: single proprietorship owned by a Filipino citizen, partnership with at least 60% Filipino ownership, corporation with at least 60% Filipino ownership, and board of directors. Required documents: business name, certificate or articles of incorporation or partnership, mayor's permit or municipal license, resolution of the board of directors or owners, letters of authority, list of officers and employees, marina documents, certificate of inspection, CPC, PA, or SP, compulsory passenger insurance, rates and routes, and any other required documents. Seatbelt law. The seatbelt law was enacted to secure and safeguard its citizenry, particularly the passengers and drivers of private and public motor vehicles, from the ruinous and extremely injurious effects of vehicular accidents. In order to secure the safety of passengers and drivers at all times, the mandatory enforcement of the use of seatbelt devices by the drivers and front seat passengers of private and public motor vehicles shall be enforced. Law on transportation of animals. By virtue of Republic Act 848565, also known as the Animal Welfare Act of 1998, it shall be the duty of any operator of any land, air, or water public utility transportation pets, wildlife, and other animals to provide in all cases adequate, clean, and sanitary facilities for the safe conveyance and delivery thereof to the consigned and the place of confinement. Anti-Carnapping Act of 1972, Republic Act number 6537. Customs must report imported motor vehicles to the Land Transportation Office within 7 days. Philippine Clean Air of 1999. Vehicles must meet emission standards for LTO registration. Seatbelts Use Act of 1999. Republic Act number 8750 prohibits importation of vehicles without operational seatbelts. Public service laws. The law. Public service includes every person who may own, operate, manage, or control in the Philippines for hire or compensation, with general or limited client, whether permanent, occasional, or accidental, and done for general business purposes. Any common carrier, railroad or street railway, traction railway, subway motor vehicle, steamboat or steamship, line, ferries, and watercraft shipyard. Traffic Laws, Republic Act number 4136, which is enacted on June 20, 1964, is a compilation of laws relative to traffic rules and regulations. Some of the highlights of the law are as follows. Number 1, registration. No motor vehicle on public highways without LTO registration. Tourists can use their vehicles for up to 90 days without registration, given they display current number plates and register with the Land Transportation Commission. Number 2, public utility vehicles. Registration requires a certificate of public convenience and compliance with public service law. Number 3, driver's license. Must have a valid license for the current year, carried at all times, and shown upon demand. Number 4, capacity and safety. No overloading of passenger or cargo. Sufficient car accessories such as tires, brakes, horns, lights, etc. Must have at least 1 pair of each warning devices. Limited Access Highway Act. Republic Act 2000. Number 1, authorization. Department of Transportation and Communications designs and regulates limited access facilities. Number 2, Administrative Order Number 1 in 1968. Prohibits motorcycles, pedicabs, tricycles, and bicycles on limited access highways. Number 3, regulation. Regulation of public highways is an exercise of state police power. Reasonableness of regulations is based on human judgment and specific circumstances. So let's end this discussion with a quote. Success is not the key to happiness. Happiness is the key to success. If you love what you're doing, you will be successful. By Albert Schweitzer. So this quote means that success alone does not guarantee happiness, but being happy with what you do leads to success. Then when you find joy and passion in your work or life, pursuits you naturally put in effort, just stay motivated and achieve great results. Loving what you do creates a positive mindset, which ultimately attracts success and fulfillment. So thank you for watching. Once again, I'm Jade Claire G. Downing from BSHM 3A, and see you on the next chapter.